Thank you, Margot, and thank you, Joe. And by way of introduction, I just wanted to very quickly say that this talk follows on from a book I co-wrote with Rhiannon Marklis on arbitration in 19th century England, and that was published earlier this year. It came out as the last in a series on the history of arbitration, either written or co-written by the great Derek Roebuck, which covers ancient Greece and Rome and then England through at least the 8th to the 18th centuries, although you may be glad I'm not going to make my 18th century quite that long. So arbitration is the settling of disputes by one or more party-appointed arbiters, and it has very deep roots in English society, as Derek's series has shown. It might not be quite so widely recognised a process in the 21st century, but in 1806, it carried enough cultural recognition to inspire a stage show, Frederick Reynolds' Arbitration, or Free and Easy, a musical farce, which was first performed at the Theatre Royal Covent Garden. The prologue of Arbitration purports to be a letter sent with the manuscript of the play and reads thus: "It has this merit which you'll call good sense, it will not ruin you by its expense, no pomp, no show to make your treasury groan, no foreign aid employed, 'tis all my own. True English growth and manufactured here, broad native character and homemade cheer." This excerpt contains many of the tropes of Georgian theatre, with its patriotic fervour not least amongst them. Yet it was also adequately well informed about arbitration to riff on associated language. So merit in the first line echoes the legal phrase "to decide on the merits of the case," meaning without technical or procedural objections and based upon good or common sense. The prologue also raises other important themes to understanding arbitration, such as its relationship with the law, which is associated with pomp and show, and their relative cost as modes of dispute resolution. The claims about the Englishness of the play and its broad native character, and by implication, of course, arbitration itself, may at first seem like a throwaway line designed to appeal to an audience living through the Napoleonic Wars and encouraged to a zenith of both patriotism and xenophobia. However, the idea that there was something quintessentially English about the process of arbitration was expressed across 3 centuries. These claims pertain both to the interaction of arbitration with national institutions and its suitability to the political and legal systems of England, but also the compatibility of arbitration with the individual Englishman. Common traits or expressions of national character were said to uniquely suit the process of arbitration. Even modern historians have joined in with these claims. For instance, in a 2007 article about honour and reconciliation in the early modern period, Linda Pollock claims that, to quote, "English communities in particular were culturally averse to quarrelling, preferring to achieve consensus and minimise upheaval." This talk seeks to examine what it was about arbitration and its place in society that meant claims to its Englishness were repeated over so many years. It also explores the associated claim of the Englishness of the rule of law and whether that supported or detracted from the status of arbitration. The formation of Englishness in the courts is already an object of study, but I think there is an opportunity to take a wider view of the culture of dispute settlement and explain its importance to forging a national identity. Most notably, in the 18th and 19th centuries, the increasing association of Englishness with individual freedom in the Lockean model made arbitration attractive for its voluntarism, while drawing criticism for bypassing the right to trial by jury. The seeming tension between arbitration and the law has been a long-standing assumption. Although it has since been debunked, it was a theory posited by modern historians of the late medieval period that the widespread use of arbitration was a sign of dysfunction in the common law. Similar concerns were voiced in the 19th century by legal professionals and the commercial class about the contemporary state of the law and frequent resort to arbitration, apparently in consequence. Lord Campbell also suggested that the legal profession were particularly hostile to arbitration as it threatened to reduce their take of court fees and thus their livelihoods. However, arbitration and the law have been shown to be largely mutually supportive, even when wider discourse did describe them in opposition. Of course, arbitration was turned to in particular cases where the courts did not supply an adequate solution, but it was a far more widespread, normalised and culturally embedded process that was not merely turned to at abnormally fraught moments in history or when the courts were overwhelmed, whether by volume of actions brought or their own inefficiencies. Arbitration remained a popular method of dispute resolution across centuries and in a wide cross-section of society because it was consistently effective, retaining reasonable levels of compliance. This relied upon a careful balancing act, requiring it to possess both stick and carrot. The stick of enforcement started with community pressure, but ultimately fell back on state power, surviving the transition from a feudal system to rule by parliament and law. The carrot was a combination of practical and reputational advantage. Crucially, arbitration was often thought to be cheaper and quicker than going to law. Yet perhaps even more important was its place in national discourse, the perception that it was voluntary and the impression that participation was indeed an act entwined with community and nation, predicated on status, reputation, and a network of obligation. The identification of arbitration as uniquely English certainly highlights the status it enjoyed. Yet much like English democracy and law, English arbitration remained ill-defined and relied on a contested sense of tradition and shared notion of consent. These concepts were both strongly held and at the same time perhaps counterintuitively nebulous, resulting in a process that was both durable, rooted as it was in the national consciousness and the actual practices of communities, and also flexible, adapting to changing needs and realities. It is important to understand the meanings ascribed to this institution alongside the law to help reveal the place of concepts like peace, justice, fairness, and due process in national self-reflection. What is more, the importance of arbitration is very difficult to quantify. The challenge of counting levels of arbitration in a meaningful way, especially when it was not registered with the courts, and it's a very diffuse archive that kind of comes up almost at random in private papers, make qualitative analyses covering a long period all the more vital. Like the law, arbitration was subject to outbursts of praise and blame as it was adapted to the needs of disputing parties and the changing culture, society, and economy in which it was used. What is more, arbitration and the law reached an effective accommodation as legislators and the judiciary smoothed over what difficulties they had with its operation, a process which drew arbitration into the orbit of the courts, increasing the use of court registration and legal procedure and establishing a more definite right of judicial review. These changes made arbitration more palatable to the legal profession, whilst lending it the binding contractual terms and enhanced enforcement offered by legal recognition. At the same time, arbitration became less distinct from the law, and I think that factor goes a long way to explaining why it is not so widely recognised now. The claim that arbitration really was a unique part of English or British culture that contributed to exceptional economic and technical advances associated with the Industrial Revolution, which is a claim made briefly by Joel Mokyr, has so far concentrated on its place in commerce. The historic understanding of arbitration was in fact much broader and is linked not just to the law, but phenomena including interpersonal violence, which came to be associated by the Victorians with foreign and especially Latin hot-bloodedness. The English, by contrast, were characterised, even in the courtroom, as firmly in control of their passions. And I should say characterised by the English themselves rather than by others. Violence, law, negotiation, and mediation and arbitration were all options for settling disputes, and you can see here a loose categorisation on their relative informality, although, of course, it's not completely set in stone. Both descriptions and practical uses of them help us to understand the type of society the English aspired to and how they wished to govern their interactions with business associates, but also the rest of their community. Arbitration, as part of a wider willingness to play by the rules, became part of how the English understood themselves, a sometimes aspirational mantra that nevertheless formed both a practical part of governance, society, and economy, and a point of difference with so-called foreigners. So I now want to look a bit closer at that claim of the Englishness of arbitration. Edward Chamberlain, whose book you can see here, explained in 1672 that while in foreign lands the court sat all year round, the same was not true in England, as, to quote, "The English have always been given more to peaceableness and industry than other people, and rather than go so far as London and be at so great charges with attorneys and lawyers, they will refer their differences to the arbitration of their parish priests, who do or ought to think it a principal part of their duty to reconcile differences within their parishes, or to the arbitration of honest neighbours." Chamberlain added that they might also submit their differences to the arbitration of judges of assize. Chamberlain conceived of arbitration within a Protestant worldview of hard work and neighbourliness, reinforced by placing the parish priest at the heart of this system of resolving disputes within the community. He also saw arbitration as a local solution to disputes that avoided the difficulty of travelling to the central courts and the expense of legal professionals, although with the informal intervention of the assize judges an option if required. Localised arbitration was advanced as a key component in the practicalities of governance in the court system, as it precluded the need for the central courts to sit without breaks. Chamberlain travelled extensively in Europe and was made LLD at Cambridge and DCL at Oxford, so he certainly had experience of his subject matter. Over the next 250 years, the processes and expectations of dispute settlement, perhaps unsurprisingly for such a long duration, changed a great deal. Forms of dispute resolution other than arbitration declined between the 17th and 19th centuries. Litigation was less resorted to, even that which was commenced to induce a settlement and restore relations. Interpersonal violence, and especially duelling, fell out of favour. Civic and associational life were also revolutionised. Not only did urban association evolve from guild and company to club and society, other forms of collectivism, like the system of citizens watching the streets, professionalised. Other aspects of institutional participation declined precipitously by 1720, like pledging and sitting on civil juries as part of the great litigation decline. The latter was driven in large part by rising court costs, and yet arbitration remained well used and in good standing. It was certainly preferable to the vexatious or interminable prosecution of a lawsuit, with even Lord Eldon describing it as, to quote, "that more wholesome mode of resolving disputes." The claim that arbitration was essentially suited to the English character persisted as late as 1935, when solicitor and academic Charles Norden could still insist, quote, "that the Englishman is imbued from youth upwards with the spirit of the umpire and obedience to the referee's decision to an extent which perhaps is unknown in most other countries. Furthermore, he prefers a quick decision, even though adverse, to a favourable one coming too late to be of real service, or to obviate the anxieties and delays of the waiting period." I think it's especially Norden's mention of youth that points us in the direction of public schools and their increasing use of team sports as an educational tool to form character. The ethos of the gentleman amateur was a model with attributes such as one historian has described, self-control, fairness, respect for rules, and effortless participation. Norden's assertion of a preference for a quick decision chimes with the feelings of the commercial community, for whom the delays associated with legal actions were often a primary motivation for seeking alternative methods of dispute resolution, and that was often arbitration. So Chamberlain and Norden describe changing ideals of Englishness that nevertheless continued to be associated with arbitration. Chamberlain saw arbitration as a process of community-based justice that was an expression of Christian values and a counterpoint to an overbearing state. Norden's vision of arbitration is more procedural, bringing it closer to formal law. He valued a quick resolution of disputes above all else, confident that the obedient Englishman would accept the result and go back to his commercial life. Thus, commitment to justice through arbitration as a self-described national trait survived through the centuries. However, the decreasing cultural recognition of arbitration is symbolised by the appearance of Chamberlain's observation in a guide to England that ran into many editions, while Norden's was in an American law journal. And it's perhaps indicative that there was a play about arbitration, but if I were to put that on today, it probably wouldn't be quite so popular. If these writers provide our bookends, we must now understand how the link between national traits, citizenship, and arbitration was experienced by parties and arbitrators in the transition between the early modern and modern periods. So in late medieval and early modern England, dispute settlement was carried out through a variety of institutions as well as the courts, including the family, community, church, and guild. Long before Edward Chamberlain was writing his observations, arbitrators in England were chosen for their status within these groups and valued as both community brokers and important actors in the credit economy. Chamberlain's vision of parish priest as arbitrator is backed up by other evidence. For instance, in 1660, Ralph Jocelyn, the vicar of Earl's Colne in Essex, wrote in his diary that he, quote, made an end of diverse quarrels between Robert Crowe and other persons to my good content. And he added a prayer that revealed the worldview that underpinned his intervention. Lord, end thou my wrongs by pleading them, and bless me who desire peace with thee and love it, and for thy sake with all others, remember the peacemakers for the sake of the Prince of Peace. The English system of dispute resolution was not only a local affair based in the parish, but also constituted a collaboration between assizes, central courts, and regional gentry, nobility, and landowners. These figures were valued as arbiters and reconcilers for their standing in the local community and their holding of offices such as Justice of the Peace or Lord of the Manor, with responsibility for the manorial courts. They dispensed justice of varying levels of formality to humble petitioners, propped up an overburdened court system, and helped keep a potentially violent society in check. People had recourse to the courts or arms and duelling to end their disputes, but arbitration, mediation, and reconciliation were very much normal parts of English life and offered definite advantages over more contentious ways to settle disagreements. Arbitration remained part enough of social and political discourse to be suggested as the mechanism for reconciling the Whigs and Tories in 1710. The economic life of England also relied upon mediation and arbitration, which were frequently invoked to settle small debts and maintain the trusting credit relations upon which local markets were structured. Relying on the informal intervention of neighbours was usually the procedure of first resort, with the courts providing a coercive backstop. Arbitration was also common amongst merchants, trading nationally and internationally, allowing them to settle disputes according to their own conventions instead of strict law and preserving their relationships and reputations. Arbitration found even wider economic importance when used to set prices in mass transfers of land with minimal state involvement, and these were some of the most important economic developments of the day, from enclosure to the construction of canals and then railways. Even in periods of peak litigiousness, arbitration persisted as a device used to restore relations both before and during actions at law. Honour was a pervasive notion in early modern life, and it has previously been associated by historians primarily with physical supremacy in men and sexual chastity in women. But a more nuanced definition has emerged in this historiography that emphasises restraint and reconciliation, the role of the family and the collective in maintaining honour. There has been a consequent reappraisal of the role of women as more active participants in constructing a web of relationships that constituted an individual's honour. To be an arbitrator or mediator in early modern England conferred honour because it was part of that culture of reconciliation that avoided vexatious disputes or violence and valued the bonds of family and community. A successful arbitrator also considered the honour of the parties whilst disposing of their disputes. Submission to the arbitrator was thus considered honourable rather than weak or cowardly, and participating in an arbitration was an act of reciprocity within a network of obligation. The intertwined notions of honour, credit, and reputation were bound up in efforts to reconcile not just interpersonal and family disputes, but also debts. Thus, arbitrators were essential to maintaining family relations, public order, and the economy built on networks of credit and trust. Reconciling private economic disputes was one of a set of mutual obligations that was thought of as an act of neighbourliness, including lending money, offering bail, and acting as surety for a loan or executor for a will. Private reconciliation was reinforced by JPs and, as we've heard, clergymen. The magistrate and their informal role as local peacemaker often through mediation and arbitration, was a very English institution. Rose Wallace has described the magistrate's use of discretionary power as, quote, an integral part of English governments at this time. The discretionary powers of the magistracy allowed them to interpret the law to suit both national and local concerns. Office holding as magistrate or county lieutenant also enhanced honour through influence, mercy, and arbitration, facilitating displays of largesse as well as the humiliation of rivals. In the 18th century, the emerging middling sorts were associated with small producer households, whose head was an independent citizen by virtue of paying the local rates and often held office in the vestry or borough and participated in local politics. These men were community brokers who acted as trustees, executors, and sureties. And it was this kind of person who also routinely acted as an arbitrator. Well into the 19th century, Francis Place is one famous example, who describes arbitrating the commercial disputes of his peers for free. We can also point to a Quaker chemist from Stockport, a holder of several local political positions, whose obituary in 1839 cited his frequent employment as an arbitrator, executor, and trustee as evidence of his sagacity and, to quote, unsullied integrity. Acting as arbitrator formed part of a constellation of roles that denoted both honesty and status, increasingly discussed in terms of character in the 19th century. Arbitration was also seen by some as the manly response to a dispute, a term that was of course heavily linked to political participation and the citizen householder in the 18th century. Willingness to submit to arbitration was a valued trait in the contexts of both business and politics. It was even put forward as an alternative to duelling, as violence became an increasingly unacceptable expression of masculinity, even if offers to refer a matter to arbitration instead of having a duel were not always accepted in practice. The language of manliness excluded women from arbitration and the workings of justice, just as it did their participation in the political nation. The exclusion of women from the legal profession represented an accompanying practical barrier, and I've found no examples of women being officially appointed as an arbitrator in the long 18th century, although there certainly were in the 17th. The rule of law became a particular area of focus in the 19th century. It was perhaps Dicey who most clearly formulated the idea of English exceptionalism based on the rule of law contained within the Constitution and incrementally constructed by the judiciary. Dicey claimed that, to quote, the predominance of the legal spirit may be described as a special attribute of English institutions. Dicey contrasted the rule of law with, to quote again, every system of government based on the exercise by persons in authority of wide, arbitrary, or discretionary powers of constraint. It is not only the spirit of the rule of law that has been identified as English. Certain aspects of the letter of the law have also reflected English preoccupations. For instance, property law had, to quote David Sugarman, a larger cultural and political significance that played a role in inventing and policing certain ideas of Englishness, property, justice, and citizenship. Looking back to the medieval period, Maitland took a comparative approach to understanding how English law had diverged from European counterparts from as far back as the 13th century, but he decried any, to quote, hasty talk about national character. Yet Maitland also had concerns about foreign alternatives to the common law, namely the potentially tyrannical effects of Roman law. We have seen that arbitration was caught up in a similar narrative. The use of arbitration genuinely pervaded English practices in government, economy, and society, leading to claims that such usage was exceptional and that it was tied to both unique institutions and a shared spirit. If the English commitment to the rule of law was part of the unique genius of the nation's constitution, the Englishman's commitment to arbitration was also tied up with his personal constitution, his character. Yet even as the rule of law and commitment to arbitration were hailed as uniquely English traits, perceived clashes between the two were raised in the 18th and 19th centuries, questioning whether each was compatible with other English ideals and institutions. This was a potential problem for arbitration. As Chantal Stebbings has identified, there was a 19th century belief that the courts and their independence from the government were, to quote, a major safeguard to the rights of free Englishmen. One of the most important objections raised against arbitration was its circumvention of one of the totems of English liberty, trial by jury. However, the English legal system was not without its detractors either. While the principle of the rule of law held general approbation, its manifestation and practical application were not so universally respected. Lawyers in particular were often derided for their greed. Their use of legalese and procedural nicety was also a point of contention, needlessly obscuring the reality of the law from the common man and wasting his time and money. Arbitration had the potential advantage of stripping away technicalities, Francis Place saying that he conducted arbitrations without such, as he described, grim gribber, but was not itself immune to criticism. Concerns about the association of arbitration with arbitrary power were an important factor in preventing state-sponsored arbitral institutions from being formed in the 19th century. One aspect of arbitration that was seen as problematic was its association with summary justice, and with an obvious linguistic equivalence, arbitrary power. The arbitrator had nearly unlimited discretion to decide a dispute as they thought fit, once, of course, the parties had made a binding commitment to submit their differences. In 1795, Lord Kenyon, while hearing a cause in Chancery concerning an ironworks, described the arbitrator as, to quote, the most unfettered judge in the world. In that instance, Kenyon was advising the parties to submit their differences to an arbitrator to avoid an endless court case that would drain away their money. Yet that complete discretion which made arbitrators effective also opened them up to criticism as an arbitrary power. John Brewer has described how the Wilkite movement of the 1760s and 70s saw their challenge to judicial authority as a political act, a notion which caught on more widely. Brewer describes an incident in which a prisoner came before Lord Mansfield following attachment for the non-performance of an arbitration bond, which essentially means imprisonment for not doing what the arbitrator had awarded and told them to do. The prisoner cited Magna Carta and demanded his freedom, an act of protest that placed arbitration and its enforcement through the courts as an invasion of personal liberty. Mansfield had him removed from the court, which elicited an apparently impudent bow and a smile, giving further fuel to the interpretation of this event as an act of resistance. Mansfield was a natural target for such protestations, as he was at the forefront of a movement of authoritarian Whigs who wanted to reduce levels of litigation. They attempted to limit the roles of juries and introduce some elements of summary justice, as well as promoting arbitration. Horwitz and Oldham have explored the incident further and shown that the legalisation of arbitration and its increased enforcement via contempt of court drew criticism, mostly unfairly, on the same grounds as the expanding use of summary justice, despised for its contravention of Englishmen's liberties. The late 18th century radical critique of arbitration centred on its relationship with the courts as sanctioned by Parliament as long ago as the 1698 Arbitration Act. That was pushed through by John Locke, though the effects of that change were not widely felt until Wilkes's time. Concern was also expressed about the discretionary powers of the magistrates. The extension of summary justice in the 18th century drew criticism from no less a figure than Blackstone, who wrote that, to quote, "It has of late been so far extended as, if a check be not timely given, to threaten the disuse of our admirable and truly English trial by jury." He was referring to matters in which the magistrate was officially empowered to make summary judgments, but magistrates often used their discretion to mediate or arbitrate all sorts of disputes, from slanders to assaults. Some took an extremely wide view of their remit, arbitrating disputes that could have been defined as criminal matters and if categorised as felonies should not have been open to private composition. The summary courts were often a precursor to a mediated or arbitrated solution. Although the situations in which magistrates could exercise discretion and choose to arbitrate were narrowed during the 19th century, working class violence and especially marital disputes continued to be dealt with informally. In the late 18th century, there continued to be some concern about the place of arbitration within an English notion of rights, even along observations about litigiousness. In a somewhat satirical and deeply critical overview of the English legal system, a newspaper article described litigants who were determined to try their dispute and, quote, let the consequence be what it may, for whom the only other option was arbitration. Yet the writer made the arch observation that not only could arbitration cost almost as much as going to court, they had never known both parties to be satisfied. This stemmed, to quote again, entirely from that inborn rectitude which an Englishman possesses and a knowledge of his rights, on which this is a kind of agreemental alien invasion, and who therefore presumes it might have been more in his favour had he gone in a regular manner before his country. The language of alien invasion shows that despite the consent of the parties having been forthcoming, there would in this writer's view always be an essential foreignness to arbitration, equated with a certain amount of coercion that did not agree with the English disposition. What is more, arbitration could be conducted behind closed doors, seen as an advantage in sensitive commercial or family disputes, but opening it up to accusations of secretiveness. The gradual shift of commercial dispute resolution into the supervision of the state also led to its politicisation. Christian Basset shows that as questions were raised about how public or private arbitration really was, claims either way became important in differentiating it from other examples of justice without a jury that had become politically problematic. No less a figure than Thomas Paine argued that arbitration was an entirely private affair, defending its legitimacy as a right to be defended from the state. It was Paine's ideal of arbitration, which best fits with Frederick Reynolds's play that touted dispute resolution as true English growth and manufactured here. Thus, a dichotomous view of arbitration was developing, with so-called private or ordinary arbitration praised as native, patriotic, and independent-spirited, while attempts to introduce forms of arbitration with compulsory or summary elements, or any other forms of coercive state imposition, were decried as foreign, invasive, and a threat to English liberties. That dichotomy continued to play a role in shaping state interventions in arbitral procedure in the 19th century. I won't go too far into that legislative programme today, as it stretches right into the second half of the 19th century. But I do intend to investigate further a particular and pivotal reason for the unfavourable assessment of arbitration, which is its lack of the check on state power provided by jury trials. Trial by jury was often portrayed as a cornerstone of the rule of law in England and was an obvious procedural difference between arbitration and the courts in the popular imagination. It was the lack of a jury in an arbitration that was often the target of criticism. Even the limited power of compulsory reference in matters involving complex accounts drew suspicion from ongoing supporters of the jury, as the legal writer Joseph Chitty made clear. He wrote, "The difficulty in introducing any compulsory enactment seems to be the encountering the antipathy to any invasion of the right of trial by jury, which Englishmen from their infancy have been taught to regard as their birthright." Yet the jury was by no means ubiquitous in English legal procedure, a fact well known to legal professionals who were used to various instances in which a jury was either not consulted to begin with or had to be bypassed due to the matter in dispute, particularly complex business litigation. The most obvious arenas in which no jury was consulted were the courts of equity, and they also utilised references both to court officials or others. For instance, the Court of Chancery carried out fact-finding and, when asked to unpick complex accounts, might refer them to one of the 12 masters in Chancery or, of course, an arbitrator. References to arbitration were also made from the common law courts, even after a jury had been assembled. Arbitrators were not only called upon for commercial causes. When defendant Trickle Nathan stood accused of defrauding his dumb niece at the Mansion House in 1817, the Lord Mayor, who was presiding, to quote, was fearful of the inefficacy of all he had seen or heard to bring home the guilt in the minds of a jury. Witnesses had attested to both the previous wealth and good character of the niece, who wept at her predicament, as she was only able to communicate with her situation to the court with her eyes and hands. Counsel for the defendant argued that, to quote, sufficient had not been brought forward to justify an appeal to a jury. He advised arbitration, and apparently all parties agreed to reference to the rather mysteriously named high priest. Nominally consensual, judges might be so firm that the court was not properly equipped to hear a certain matter and urge a referral so strongly that it was difficult to see how the parties could refuse. The writer of moral advice literature, the Reverend Thomas Gisborne, saw no conflict between promoting arbitration and venerating jury trial. He advised judges that, to quote, in every case which admits of being concluded by arbitration, he will earnestly recommend that less irritating mode of decision, going on to add that he will reverence the institution of juries as the safeguard of English liberty. Arbitration, its place in the legal firmament, enshrined by statute since the Arbitration Act of 1698, gave the arbitrator almost limitless power to decide a dispute as they thought fit, but only within the boundaries imposed by the contracting parties. From 1760, commercial arbitration became more legalistic, not through more legislation, but through increased interaction with the courts and legal professionals. Concerns expressed amongst the legal profession about arbitration in the 19th century were less focused on the sanctity of trial by jury. Their critique fell instead upon lay arbitrators, who might lack knowledge of legal procedure or rules of evidence. And in any case, in the 19th century, juries were losing some of their lustre. And the satire that you can see on display is from about 1815, and clearly shows that respect for jurymen was not quite what it was. The fetishization of the jury was gently mocked in the comic Blackstone, which was first published in 1844, which described trial by jury as, to quote, a subject that every true-born Briton with a quarter of a pint of Saxon blood in his veins is prepared to revel in. The writer claimed to have, quote, heard of that great bulwark of our liberties tossing up occasionally when a verdict could not be agreed upon. Juries had no place in the county courts established in 1846 and were made optional in civil cases heard in the High Courts following the Common Law Procedure Act of 1854. Commercial cases were increasingly heard by judges sitting alone, and institutionalized arbitration schemes were also proffered as a response by commodities traders. Thus, the concern about arbitration bypassing jury trials became something of a moot point. While discretionary justice exercised by individuals continued to be a facet of the legal system, alternative courts proved a more challenging concept. The idea of alternative courts, usually merchant courts, while drawing significant support, was a controversial innovation. Merchant courts had been a popular cause amongst the commercial community since the mid-17th century. John Locke had considered the Dutch model in his role at the newly formed Board of Trade, but amidst intense pressure from Tory politicians, he opted for the more expedient measure of bolstering private arbitration instead, and that came in the form of the 1698 Arbitration Act already mentioned. Rejection of such juryless courts, often led by the lawyers in Parliament, added to the claims by scholars like Dicey that they were contrary to the Anglo-American tradition of ordinary courts and private arbitration. Foreign systems of arbitration were similarly looked on with suspicion, their principles and institutions based on different cultural and legal mores. They resembled merchant courts in that they were often permanent sitting courts and included some compulsory element. The perceived exceptionalism of the English was founded on a comparative model that often emphasized an individual and collective spirit of freedom, contrasted with unacceptably invasive forms of dispute resolution fostered in foreign societies. There was also a tendency for legal thinkers to personally assess the advantages of other systems, but then interpose the English national character as unsuited to their operation. Institutional arbitration continued to be explored through the 19th century, and although individual proponents admired European examples, there continued to be an accompanying concern about whether they could be accepted by the English, as well as strong and often fatal opposition amongst the judiciary. When Lord Brougham made his great speech on law reform in 1828, he made suggestions for more institutionalized forms of arbitration. The Attorney General responded by expressing his distaste for compulsory arbitration courts, saying he should err much in his judgment as to the feelings of Englishmen if he could suppose for a moment that they would submit to a tribunal of that sort. Brown himself had similar reservations. Brown suggested that the ideal solution to an excess of litigation over small debts would be a permanent court of arbitration, as he had observed in France and Denmark, but that, to quote, the people of England would not suffer the existence of a court of arbitration. Instead, he proposed the appointment of public arbitrators. Of course, Brown became Lord Chancellor in 1830, and he attempted to put some of his principles into practice, specifically in his bid to reform the local court system. He was determined that the judges in his new local courts should also sit as arbitrators and preside over a court of reconcilement. And in doing so, he again cited Denmark as a successful model to emulate, but was also careful to ground his plan in ancient English practice, utilising the helpfully vague precedent of county courts, although he admitted there was little agreement on how they actually operated. Still, Brown felt his best chance of success lay in the idea of, to quote, new institutions in name and appearance, but old and revived institutions in principle and effect. Nevertheless, the Common Law Commissioners, asked to review his plans, immediately removed the concept of a court of reconcilement, which, to quote Patrick Polden, became a sort of King Charles's head with Brown, who tried unwearingly for the rest of his active life to persuade the invincibly insular English of their merits. Yet Brown's attempts to introduce institutionalized arbitration were only partially realized, and this took many years amidst widespread opposition, again amongst the legal fraternity in Parliament. Even the judges who acted as arbitrators themselves stressed its voluntary nature and eyed any state-backed scheme with suspicion. The County Court Judge Rupert Kettle also delved into the national character when discussing his successful forays into industrial arbitration and schemes that might produce a more regular system of dispute resolution in this field. In a work of 1870, he raised the idea of courts of conciliation and the French system of conseil de prud'homme, but counselled that, to quote, according to the spirit of our laws and the freedom of our people, any procedure to be popular must be accepted voluntarily by both contending parties. Compulsion in private affairs, except from the constituted authority of the executive government, and that upon a formal judgment of a court, is repugnant to the fundamental principles upon which our social organisation is based. The English system of arbitration remained based on the principle of private contract, with voluntary commercial institutions providing procedural norms for those that wanted them, and informal enforcement via the threat of expulsion. The courts provided the ultimate means of enforcement, while the common law filled in the rules about what happened if the parties challenged the legitimacy of their arbitration or arbitrator, although that was within a fairly loose statutory framework. Suborned to the courts, but still with the contractual freedom and separation from state institutions that made it comfortably compatible with various visions of individual, political, and legal liberty, arbitration was, by the end of the 19th century, the largely unchallenged friend to the English, championed by Charles Norden. To conclude, the place of arbitration in economic development is undoubtable, but despite a growing literature, needs some clever quantitative and comparative work to make more concrete conclusions about relative importance. And I think at that point, we'll be able to speak more to its importance in the Industrial Revolution. This talk, however, hopes to cite arbitration within discourses of Englishness, which necessitates an examination of the relationship between arbitration and the law. The association of both arbitration and the law with notions of Englishness was an attempt to define them in a particular way. In the positive, it evoked notions of fairness, honesty, and simplicity. They were suited to an English national character, often personified as John Bull. Their success was built on the shoulders of the citizen of classical republicanism, shaped by virtue and virility, then sustained through the 18th century as polite, commercial, and manly independence. Of course, political discourse changed across this long period of roughly the late 17th to the mid-19th century, but a thread held together the language of honour, reputation, and good credit that were applied to both arbitrators and parties who referred disputes to arbitration. These were also attached to adherence to the rule of law, but not the litigious or legal professionals. Another aspect of citizenship, serving on a jury, became central to the English vision of the rule of law and an important reason to deride arbitration, despite its deep roots in English society. Alternative visions of both arbitration and law were presented that linked them with foreignness, a condition most closely associated with the French, but taking on wider meaning as the British Empire expanded and communications improved. The foreign denoted despotic rule or arbitrary power, trickery, dissembling, and a lack of authenticity. It might also be associated with effeminacy and subservience. Different aspects of both arbitration and the law were attacked in these terms. Arbitration, and especially compulsory or statutory institutional arbitration in the 19th century, was conjoined with its etymological cousin, arbitrary power. It was occasionally maligned as a secretive proceeding with none of the public access of a courtroom. And this was, of course, at a time, at least until 1872, when voting was conducted publicly. Legal proceedings were derided for their unnecessary expense, partly driven by the avarice of lawyers and confusing technical language that presented a barrier to common understanding. Arbitration survived and indeed flourished despite such popular criticism, especially as jury trial became less of a sacred cow. A separate critique of arbitration, mostly mounted by the legal profession, that it had few of the procedural safeguards of the law and was therefore un-English, was successfully deployed against the establishment of any institutions that would be parallel to the ordinary courts, especially if they were combined with any element of compulsion, like merchant courts, arbitration courts, courts of conciliation, or tribunals of commerce. That attitude no doubt also contributed to the slow legalization of arbitration, bringing it closer to the personnel, processes, and supervision of the law, but I think bringing it out of the public consciousness. Thank you.
That's great, Francis. Thank you very much. You've given us a really capacious field to play on there, not just chronologically. Even for us, it's a wonderfully broad 18th century, but also covering a lot of the law.